Good morning, everyone. Thank you very much. I hope you've been enjoying the conference thus far. I think we're feeding back a bit on the mic. Please, could you turn it down a touch? Hello? Okay. Is anyone up there? Probably not. Okay, we'll pretend that microphone works. I'm Rick Lyons. I'm the Executive Director of Harm Reduction International, and we're very pleased today to put on this important session on the death penalty for drug offences, particularly under the title of Ending the Death Penalty for Drug Offences. I'm very privileged to have joining me to co-chair the session our colleague Aurélie Placé from the World Coalition Against the Death Penalty. When Harm Reduction International started doing work on the death penalty for drugs back in 2007, there was really no one, either in the drug policy sector or the human rights sector, who was doing focused thematic work on this particular issue. And over the course of time that we've been working on it, we've been pleased to see the issue go from rather obscurity to a real mainstream part of the debate, both within the abolitionist sector, within the drug policy sector, and even within the United Nations, where it's emerged as a key sort of point of tension within the international drug control regime, exposing the ways that the regime fundamentally compromises human rights protections in many instances. We wanted to focus today on the topic of ending the death penalty for drug offences and give a chance for four of our colleagues to talk about work and activities going on in four key death penalty states. I think there's very often a misunderstanding or an assumption that death penalty states are monolithic politically, and that somehow there aren't opportunities to challenge human rights abuses. Well, in fact, we have vibrant human rights communities, activists, lawyers, operating all over the world, and this is an opportunity for us to talk about some of the ways and to hear about some of the ways that that work is being progressed at the current moment. And I'm joined with our colleagues, Tripti Tandon from the Indian Lawyers Collective, Sharmini Darshni from Amnesty Malaysia, my good friend Dr. Biying Shi from the International Center on Human Rights and Drug Policy, who works in China, and Ricky Gunawan from Indonesia. And our first speaker today will be Tripti Tandon from the Indian Lawyers Collective. So Tripti.
Thank you, Rick, and a very good morning to all of you. Of course, Rick, in a very humble manner, talked about the work that HRI has done on this, but I want to start by just acknowledging his report of 2007, the very first on the subject of the death penalty for drug offences, which, in India, the Supreme Court imposes the death penalty in cases which shake the conscience of the nation. And to me, Rick's report actually shook my conscience, because the death penalty is wrong and so is drug prohibition. And it's a compounding of two wrongs which had gone unnoticed by many of us in the human rights and the abolition sector in India. And what is most shocking from this report was the fact that while internationally there was an abatement in or a move towards abolition, but the drug sector actually saw more and more countries adopting the death penalty. And this really was something that shook me to the core. And fortuitously, within 2 months of me coming across this report, we had 2 death sentences being pronounced under India's narcotic law. 2 drug courts, one in Mumbai and one in Ahmedabad, the state of Gujarat, imposed the death penalty on people convicted for trafficking. Both cases incidentally involved cannabis. Subsequently, we've had 3 more people being sentenced to death by the first court, that's the Sessions Court, one again in Gujarat and 2 more in Punjab. India's law on the death penalty for drug offences is slightly different from what you see in the rest of the world, including this region. Our capital offence was introduced in 1989, 4 years after the drug law came into force. And the reasons are kind of mixed. It's very difficult to pinpoint what exactly was the trigger, but it seems to be a combination of domestic, regional and international factors. So internationally, of course, India had just signed up to the 1988 convention, which we know is the most stringent one on drugs as far as international law is concerned. Also regionally, and India loves to blame its neighbors for all its problems, and so the nexus between terror and drugs from across the border was also somewhat of a factor. And of course, domestically, we were reeling in a state of complete drug paranoia, this whole fear around heroin and heroin addiction, and perhaps that's the reason why we chose to take on capital punishment. The sentence, as it was introduced, was mandatory and imposed for a second offence, which involved a substantial amount of narcotics. As you can see, the threshold here is fairly high in contrast to other countries. There was a challenge in 1998, but the court rejected it because it was academic. Nobody had been sentenced till then. There were amendments carried out in 2001, which narrowed down the scope but retained the mandatory nature. There are certain other peculiar aspects to our law, and I'm just going to touch upon some. The subsequent offence, of course, the intention was to guard against recidivism, this belief that those who have served a first sentence for drug offences and are incorrigible and then re-offend should perhaps be awarded the death penalty. But that's not how the section has been applied. In many cases, the person having been arrested for a first offence confesses to having kept narcotics in another place. And this is a classical case where somebody was arrested for drugs found in one city, and while he was being investigated, he apparently confessed that he's kept some drugs in another city. And that then led to the imposition of the death penalty. In some cases, people are being tried in two different courts, and it's only a matter of time which court convicts you first, and then subsequent becomes the death sentence. In contrast, in some cases, the courts have been careful and have waited that the first conviction should actually have attained finality, as in your appeals in the Supreme Court should have been dismissed before you will actually be proceeded on for sentencing for the second offence. The other part is the quantity-based penalty. India's law only looks at the amount of drugs and does not look at your role or what you are intending to do. And there's a huge controversy as to whether prosecution and punishment should be on the basis of the pure drug or the actual amount of narcotics when it's mixed with other things, or should it be the gross weight. There's also no independent corroboration. Whatever the police, at the time of seizure, whatever quantity they record, if it's 2 kilograms recorded by the police, it becomes 2 kilograms. There's no independent corroboration of that. Also, fair trial safeguards may be compromised. Confessions to police, of course, are not admissible, but courts have held that anti-narcotics agencies and their officers are not police, and therefore they are admissible. There is also the presumption of guilt. It is up to you if you are accused to prove that you were innocent. And in many cases, courts say that the person had nothing to say in defense, and therefore their guilt is sort of palpable. This is when the Lawyers Collective started intervening in the issue. We mounted two challenges, constitutional challenges to Section 31A of the drug law. One in the Bombay High Court, and both these were courts where the appeals by the two convicts were pending. The Bombay and the Gujarat High Courts. The Bombay case was, of course, heard and decided first. The court quashed the mandatory nature of the sentence but preserved the death penalty as a discretionary punishment which could be awarded when the court found special reasons. The Gujarat case, of course, was withdrawn because the convict, of course, the sentence was commuted in both the Bombay and the Gujarat cases, and therefore there was the court didn't find it there's no reason enough to continue with the challenge. We of course appealed in the Supreme Court because we felt that the Bombay High Court ought to have quashed the death penalty entirely, the entire section, and not read down the law with reasons, etc. That petition is still pending. And we also subsequently filed a case directly on behalf of one of the death row convicts, but the court didn't entertain that, saying go to the High Court first. And of course in the High Court the person chose not to challenge the sentence but merely go forward with his appeal, and his sentence too has been commuted. So as of date, of the 5 death sentences for drug offences in India, 3 have been commuted to life on the basis of the Bombay High Court judgment. The status of one is unknown and the appeal of one is pending. The Lawyers Collective also intervened at the level of the Parliament, and this was a big risk that we took. It's of course easier to, and I say that with a pinch of salt, it's easier to challenge a mandatory death sentence, which constitutionally as well as internationally is known to be contrary to settled norms of human rights and fundamental rights. When it becomes discretionary, the challenge is very difficult, but we kind of took that risk, made submissions to the Parliament asking for abolition. Parliament considered but said we are happy with the discretionary death sentence. And of course, while our legal work managed to save 3 lives, I think in the long run we may have kind of foreclosed the opportunity of of getting rid of the entire section. Let me just introduce you to some of the arguments that were made both in court as well as in Parliament, and the counter response that came from the state authorities. So of course, Rick's work that the drug offences are not the most serious crime, and the government's answer to that was that it is for Parliament to decide. And it's interesting, I was reading a commentary where somebody said that an offence is considered serious if Parliament chooses to impose the death penalty for it. So whatever Parliament chooses to make a capital crime, that offence should be considered the most serious offence and not the nature of the offence. So interesting. We also argued that in India the death penalty is reserved for the rarest of rare cases of murder. This is of course the seminal judgment of the Supreme Court in Bajjan Singh, but the government's counter is that drug crimes are more serious than murder. And this is a quote from the Indian Supreme Court which says, murder takes 1 life, but drugs destroy the entire society. So therefore, we also argued that the conventions, of course, don't mandate capital punishment. The government's answer is that all the 33 countries that have drugs as capital crimes are signatories, and also the INCB has looked at India's legal response carefully and has never objected to the death sentence. Of course, we argued that drugs don't kill, drug dependence is treatable, so even if there is harm, the harm is reversible. The government's answer is that a person who uses drugs is condemned to a life worse than death. Quantity-based distinction is arbitrary, and of course India's answer is that we are much better than some of the other countries in our neighborhood that impose death sentence for even like a few grams of heroin. Of course, they were hinting at Singapore and Malaysia. And of course, the argument that it's excessive, especially because it applies also to license acts. India does license drug activity, and any inadvertent breach of a license results in prosecution and conviction. And of course, their answer is that we need deterrence. And I vividly remember how a member of parliament quoted a UNODC report showing growing opium production in Afghanistan as a justification for the death penalty, as though poppy crop there doesn't respond to the weather or to soil, but to the punishments in India's law books. We've had several other developments which are relevant for the discourse. India has introduced the death penalty for a second offence of rape. Again, this is not something that involves the taking of life. Of course, it's a violent crime. The Supreme Court has recently upheld capital punishment for kidnapping for ransom, even when the victim is not killed. So the more serious crime, the taking of life argument is sort of diluted in our jurisprudence. The court has also raised the bar of the proportionality review. Earlier we had nothing, but now the courts come up with not just barbaric or inhuman or disproportionate, but the adjectives of outrageous, palpable and shocking. I don't know what it would take to satisfy this test in order for a sentence to be struck down. On a positive front, the Law Commission has recently recommended abolition except for terror offences. So clearly drug offences have been recommended to become without capital punishment. As in the course of our work, both in courts as well as in Parliament, we've come across several dilemmas, and I'd like to just pause here for a bit and perhaps invite comments also from the other speakers. So of course we've got a lot of literature now, reports and publications saying internationally the death penalty for drugs is a big no. But the region here is replete with laws that impose the death penalty, and this is something that the Indian government said in court, that India can't be an oasis for drug traffickers. And I think some attention perhaps needs to be put in looking at the region as a whole, because when countries look to each other, they will only be encouraged to impose more stricter punishments as opposed to less. Of course, one big dilemma for all of us, especially us as human rights lawyers, is that should there be a push for total abolition, abolition per se, or a focus on drugs. And in our experience, if there's, the minute the kind of the media discourse becomes pro-abolition, or even recently with the Law Commission recommending, there's sort of a pushback and a rebound, both from courts as well as from ministers and parliament saying, no, we want the death penalty. And of course, the drug terror nexus and this rhetoric around narco-terrorism is very, very prevalent in Indian courts and parliament. And it's a big risk factor as far as the death penalty for drug offences is concerned. Should it be linked to other aspects of drug law reform, or should it be a singular focus? While, of course, most of us sitting here would like to reform drug law and policy in totality, but the danger is that if the demand for abolition comes with the demand for decriminalization, the governments may just dismiss this as being soft on drugs, which I don't think many countries in Asia want to do. So there's a bit of a issue there. What about getting other stakeholders? And this was quite telling because the Lawyers Collective has done extensive work around drug law reform recently, especially around medical access to opiates. And, it was quite surprising when people who we were working with, doctors who work with patients who require morphine, saying, give us our medicines. We are the legitimate people. Hang those illegitimate persons. Hang those illicit traffickers. We don't care about them. We only care about what we need, which is medical access to opiates. And it's also similar because, remember, India's threshold is so high that drug users perhaps will never face capital punishment. The quantity involved is pretty high, and I don't think most drug users will ever be caught with that quantity. So people who use drugs have also not really been in the forefront of demanding abolition. And sometimes, what you hear at these conferences, that drug use should be decriminalized, but the other big guys should be subject to stringent punishment. I think that's very dangerous, because the stringent punishment then leads you to things like the death penalty. And of course, our parliament and court have just been looking at each other. So the court says, parliament has decided to keep death penalty, so we'll stick by that. Parliament says court is more heinous than murder, so it's a bit of a logjam there. I'm going to finally end with this I'm not sure how this will be taken, but I think one of the big contributions of HRI's work here is, like I said, getting international attention onto this issue, and then finally getting the INCB, an agency that we love to hate, to actually endorse abolition. And it's funny that, at least in India, the government doesn't listen to civil society, doesn't listen to lawyers, it doesn't listen to sometimes its own ministers and staff, but it listens to the INCB. INCB's words are taken very seriously. And I'm just wondering whether the final nail in the coffin could be laid by the INCB, the body that makes missions to various countries. Why cannot it also talk about abolition when it's discussing other drug matters with various governments? And if it did, then I think they'd do a lot of service to an otherwise area of disservice that they have done. So thank you very much.
Thanks very much, Tripti. I think to put that INCB statement in a bit more accurate context, we can't really take credit for it, but what happened, the backstory to that actually is Tripti contacted us during the context of the Supreme Court challenge because the government had made the case that she articulated that the death penalty must be acceptable because the INCB has never commented on it. And she asked us what did we think, and we thought, well, this is the perfect opportunity to now ask INCB. Because civil society had been sending them letters for years and they just ignore us. But this is actually a legal case before a major constitutional court in which the INCB has been used as a rationale. And we thought, well, this is actually a much better opportunity to actually try to force them to make a comment on it one way or another. So we worked with the Lawyers Collective to write the letter that you guys wrote as part of your court case. And it was a few weeks after that that INCB made that announcement at the C&D. So it's actually much more up to you. I'll pass over to Orly now, who will introduce our next speaker.
Thank you, Rick. I'm not presenting Dr. B. Mishi. She is a senior research associate at the International Center on Human Rights at the University of and Drug Policy, at the University of Essex in the UK, and she obtained her PhD recently at the Irish Center for Human Rights at the National University of Ireland, Galway. Her recent work focuses on the drug policy and human rights and drug policy control in China. And this is really important because, as some of you may know, China is the world leader in terms of executions, including for drug-related offences. So, thank you.
Good morning, everyone. I hope you all feel very exciting to have the death penalty as a topic for the very first day of the conference. I think it's very hard to have a death penalty as a topic, but without mentioning China. So today, I'm very honored to be here to share some of my research outcomes on the death penalty for drug crimes in China. Before I dive into the main topic of today, this panel about ending the death penalty for drug offences, I'd like to provide you some background information on the death penalty for drug offence in China. According to the criminal law of China, only the most heinous crimes can attract the death penalty. Obviously, the drug offences has to be considered as one of the serious crime that the death penalty can be applied. Namely, Article 347, which reads as, whoever smuggles, traffics, transports or manufactures drugs and commit any of the following acts can be sentenced to death. I want to draw your attention that it's not mandatory because, as the law says, the sentence can be sentenced to fixed term imprisonment of 15 years or life imprisonment or death. So the acts are listed as this. For example, if trafficking herring more than 15 grams, it may trigger the application of the death penalty, or if it's a gun dealer, or if involved in organized international drug trafficking, the sentence can be reached to capital punishment. Besides this article, there are other provisions I'd like to mention, not all of them, but a few, which can increase the possibility to apply the death penalty for drug offenses. For example, as this article reads, when it comes to the drug cases, the purity of the drugs that involved will not be considered. That is to say, for example, if in one case 2 kilograms herring has been seized, but the actual herring in that packet, the purity is only 20 grams, but when considered in that case, the 2 kilograms is be considered. It's not 20 grams, if you understand what I mean. I just want to add that last year, their judicial interpretation has been issued. In that interpretation, it has mentioned that when it comes to the death penalty cases, the purity of the drugs need to be considered. So this can be said as one of the movements that China taken to restrict application of the death penalty, even in the case of drug crimes. Another provisions that may increase the possibility to apply the death penalty is this one. Say, if someone commit the drug crimes again, the heavier punishment shall be applied. Okay. So with, I won't go on because I'm not here teaching law students. I was before. So with a legislation as such, in practice, there are many death penalty cases for drug offenses. I don't have the accurate numbers. As you may know, the death penalty cases is a national secret. But it has been estimated that hundreds death penalty cases for drug offenses in China every year. I don't know because I don't have the data here. It could be because according to the national annual drug reports, the drug crime cases in China reached 90,000 per year. With such large crimes, is possibility there will be hundreds of death penalty cases of drug crimes. So here my question is, which with a legislation as such and with a practice as such, is that possible to say that China will ending the death penalty for drug offenses? There are both opportunities and obstacles. The opportunity will be the first to change the law, and the second to ratify international treaties. So for the first one, to change the law, was that possible? I don't know if you already aware that for the recent years, China has taken steps to reduce the number of the crimes that can attract the death penalty. In 2011, 13 crimes has been moved from the death penalty list under the criminal law, and most recently, this year, August, the 9th Amendment of the criminal law has been passed, and it will take effect the first day of November, just 2 weeks away. According to the 9th Amendment, another 9 crimes has been removed from the death penalty list. So that means within only less than 5 years, and 22 crimes has been removed from the death penalty list in China. That's quite dramatic because it took 1/3 of the total crimes that can attract the death penalty under the criminal law of China. Because before the total number is 16.8, now is cut down to 46. So with such a movement, is that possible to, or is that convenient to argue that China will abolishing the death penalty for drug offenses? I can't give you an answer, but you can expect that, because to reduce the number of crimes that can attract the death penalty is reached agreement both in academic field and political field, that's China will move that end. But still, I'm very cautious to make this exemption, because it's not like those 22 crimes that has been removed. Those crimes are non-violent economic crimes. Most importantly, in practice, those crimes seldom or even never attract the death penalty cases in the past decades. But the drug crimes is different. In China, the drug crime has been considered as one of the most serious crime, and it not only damages society, it grabs the economic development, and it also shakes the national security. So with such consideration, also, as I mentioned before, the practice there many drug cases and even death penalty cases of drug crimes, it might be not that easy for China to move the death penalty for drug offenses. Besides this, there are many other facts that will make the abolishing of the death penalty for drug offenses even harder. First, there's strong political will that China should take crackdown policy towards drug crimes. That means for serious drug crimes such as drug trafficking, severe punishment should be applied, including the death penalty. Besides political wills, there are also strong public opinion. There I give you a data It's a research done by one of the leading university, Wuhan University in China, and Max Planck Institution in Germany. And the survey shows that almost 16% of the responders support the death penalty for drug dealing. And the percentage among professional groups even higher. When I say professional groups, is lawyers, judges. So you can tell from the percentage, you can say that the public opinion toward drug crimes is the death penalty shall be applied. And also, I would like to mention that we can't forget the national situation in China. First, as I mentioned, there are many drug crimes. Also, we are in a region that many other countries around share the border with China that have death penalty for drug crimes as well. So with a consideration of regional cooperation, regional security, all this consideration will make the government not so comfortable to ending the death penalty for drug offenses. Just to mention a little bit that this year's harm reduction conference is calling the leadership. So I was wondering if China abolished the death penalty for drug offenses, maybe it's more easy for countries in this region to make the movement, or not China, for example, if Singapore made the movement, that would be more easy for other countries, because now when they make the argument, they will say, oh, say China executed drug offenders, just some thought. Okay. So it's not so easy to say that China will change the law to ending the death penalty for drug offenses. Then another opportunity is to ratify international treaties, namely International Covenant on Civil and Political Rights and its Protocol 2. And the Chinese government has committed publicly that they will ratify the International Covenant on Civil and Political Rights. So it's possible one day after ratification, China will abolish the death penalty, and which will ending the death penalty for drug offenses. It's possible, but I don't know when. Because there's still some issues need to be addressed before China can very comfortably ratify the convention, because say issues such as detention, fair trial standards, all these issues need to be addressed before China ratify the covenant. I won't go down to that path too. Before Tripti, right, her name, sorry, has made very good presentation on the argument between the people who support abolishing and the people who are against abolishing. I won't present again because a similar argument also take part in China. Now I want to move to the final part of my presentation is, if, as I present, it's not very easy for China to ending the death penalty for drug offenses, both by changing the law or ratify the international treaties. So what we can expect, or what is the future for the death penalty issues for drug offenses in China? There are 2 points I'd like to mention. First one, reduce the number of crimes that can attract the death penalty. Here I had a quotation you can read. It has reached the agreement that even if it's not a reality for China to abolishing the death penalty, but to reduce the number of death penalty offenses is suitable. Actually, that's what China has worked on at the moment. As I mentioned, 2011 removed 13 crimes. This year, another 9, and expect that the number of crimes will be reduced gradually in the following years. So maybe one day, I don't know, 5 years, 10 years, 20 years, the drug offenses will be on the list. Actually, I just want to mention, during the discussion period of the 8th Amendment of the Criminal Law, that 2010, actually the death penalty the drug crimes were included in the discussion paper to be ended of the death penalty, but unfortunately it's not approved in final. But I didn't say that the 9th Amendment, they are bringing it up again. No, they didn't. So with such a movement, we might expect that one day the death penalty for drug crimes will be ended. And here I give you some of your data to support my thinking. Before 1997, that's the year we have the criminal law, which we have at the moment in China. The death penalty numbers reached the peak, that is 71. And for the 1997 criminal law, the number of crimes that can attract the death penalty is 68, as I mentioned. And you can see the number is go down. So hopefully it's go down, 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 and zero, okay? Reduce the number of crimes that attract the death penalty is one thing we can expect. And another one is the restrict application of the death penalty for drug crimes. You may know from 2007, all the death penalty cases will be reviewed by the Supreme Court. It has been believed that this action will reduce the number of people has been executed, and also protect the rights of those people who are subjected to the death penalty. And also there another policy I want to mention is called less kill and caution kill. Less kill is particularly designed to reduce the number of execution, and the caution kill means that the death penalty cases shall be very carefully examined to reduce the possibility of any mistaken sentence. Okay, I think that's all for my presentation, and I do hope one day, if I can present again, I will say, okay, China has abolished the death penalty for drug offenses. I have nothing to say.
Thanks very much, Yingxi. Our next speaker is Sharmini Darshni. When Tripti was talking, she talked about the importance of actual cross-collaboration within the region, particularly on the issue of the death penalty. And I met Sharmini just a few months ago at a very important congress where Aurelie was also at, and Ricky was there, on the first Asian Regional Congress Against the Death Penalty, which was held here in Kuala Lumpur, which had anti-death penalty activists from across Asia attending and speaking. It was a really important event and had a plenary session on this particular topic. And actually at that meeting, ourselves and the World Coalition organized a side meeting of abolitionist organizations specifically to try to build bridges between the harm reduction and drug policy community and the anti-death penalty movement on this particular issue, specifically with a focus on the UN General Assembly Special Session on Drugs in 2016. So it was an important meeting and hopefully an important opportunity to do some collaboration across sectors on this issue. But now I'll turn over to Sharmini. Oh, and I should say, Sharmini was with Amnesty Malaysia. I'm sorry.
Thank you.
Good morning. Thank you very much, firstly, to Rick and HRI for inviting me to speak here this morning. I'm from Amnesty International Malaysia. I'm the ED for Amnesty. We've been working on the death penalty for the last 2 years. I have about 10 slides to take you through, but it's not as long as it sounds. Okay, first, just an overview of the countries in the region that use the death penalty. You probably already know this. China, Indonesia, Iran, Malaysia, Saudi Arabia, Singapore, Sri Lanka, Thailand, UAE, and Vietnam. I'm going to focus now on death penalty in Malaysia. Under the Dangerous Drugs Act 1952, a drug trafficker is defined as such: a person who possesses at least half an ounce of heroin or at least 7 ounces of marijuana. This is just among 2 drugs that's in the DDA, yeah? We believe that 441 people have been hanged since 1960. The problem that we have, that civil society has with the Dangerous Drugs Act, among others, is that it allows for detention without trial for up to 60 days in remand. And this is renewable every 2 years indefinitely. The Dangerous Drugs Act is one of 4 laws currently that allow for detention without trial. For drug-related offenses, there is also the mandatory death sentencing. So when you go back to the first point of what a definition of a drug trafficker is, it is the amount of drugs that is found on a person is really very, very small. But you are believed to be trafficking drugs, just because that's possession. Malaysia also practices, and it has been condemned internationally for doing so, practices secret executions. This is something that we have raised time and time again with the Malaysian government. There is also the presumption of guilt over innocence. So it is up to the person being accused of possession to prove his innocence. Statistics in brief for this year so far. You may know that Amnesty International produces a yearly report called the Death Sentences and Executions Report. So these are the figures that you are privy to first, because the report for 2015 only comes out next year. We are in the process of collecting the data, but this is what we have on Malaysia at the moment. Recorded executions, again, Malaysia practices secret executions, so we don't have an accurate figure on this at the moment. Recorded death sentences. We have 128 so far this year, which is an incredible number. 61 for murder, 66 for drug offenses, 1 for rape and unnatural sexual activities. Don't ask me details, I don't know. For half of the recorded death sentences are for drug offenses, and this is only from media reports, yeah, that we've managed to collect this data. Recorded commutations. This year so far, we have 2, 1 for murder, 1 for drug offenses. And the case on murder is actually that the gentleman who received his commutation was actually a man by the name of Chandran Paskaran. He was sentenced to death for murder, but civil society, when we found out, it was a last-minute execution, which is a slated last-minute execution, which is something that the Malaysian government also does. Families and even the person on death row is informed maybe a few days before the slated execution after spending years and years and years on death row. The gentleman by the name of Chandran Paskaran is somebody that civil society lobbied for, and that resulted in a commutation. Recorded exonerations this year, there have been 5, 4 for murder and 1 for drug offenses. In 2014, this is according to the report, the Amnesty report that I mentioned earlier, the Death Sentences and Executions report. We know of 2 executions that were carried out last year, Alagendran Velu, and the second, we have not been able to confirm his or her name, but we believe from multiple sources that there was a second execution. There were at least 38 new death sentences imposed in 2014, and I gave you the figures for 2015, and you see this has grown multifold. At the moment, we have about 1,100 people on death row, and 70% of these cases are for drug-related offenses. Malaysia and the death penalty, this is where we have regressed. Malaysia is among 20 UN member states that still uses the death penalty. The UN at the General Assembly last year presented for the 5th time a resolution on a moratorium on the use of the death penalty. Malaysia was one of the countries that voted no. And Malaysia has also rejected suggestions at its Universal Periodic Review to repeal the death penalty. Malaysia's UPR, a process that is held at the Human Rights Council, took place last year. And I will come to why Malaysia refused that consideration to abolish the death penalty in a later slide. Malaysia law versus international law. I've told you about the Dangerous Drugs Act. Malaysian law under the DDA we have the mandatory death penalty for drug trafficking, apart from also having it for murder and discharging a firearm with intent to kill or harm, whether or not any harm was caused. While involved in certain specific crimes, this involves kidnapping and rape. Under international law, you've already heard that capital punishment may be imposed only for the most serious crimes. And the ICCPR translates international law to mean intentional killing. So Malaysia, as a result, as a conclusion, does not use the mandatory death penalty or the death penalty for most serious crimes. The information with regard to the use of the death penalty is also not publicly accessible. We have approached those in the authorities officially for figures for many years. This has not been forthcoming as yet. As I speak here this morning, the lower house of parliament has its first day of sitting, parliament sitting this morning. And we know that this week, the amendments to the Dangerous Drugs Act will be put forward in Parliament. We do not yet know what those changes are going to be, but we are keeping our fingers crossed. That is not going to be worse than what is already in the DDA. One of the reasons that Malaysia rejected the recommendation to abolish the death penalty during its UPR process was because of my first point. There's an ongoing study by the Attorney General's chambers. We were told this in 2013. 2 years later, we are still not sure what the progress of this is. And that's further compounded because we had a change, to put it politely, in the Attorney General in July. So under the previous Attorney General, the death penalty was being reviewed. What the status is now, we are not too sure yet. We do understand that there was a cabinet paper that was submitted. We are not sure which stage this is at the moment. But we do know from a report that was done by the Death Penalty Project, whom I'm sure many are familiar with, judges actually prefer not to impose the mandatory death penalty. So there is support from the judiciary when it comes to abolishing the death penalty. So we are hoping that will follow through. Sometimes when we talk about the death penalty, we forget that, I don't know if you find this, but we forget that it does involve people. I'm going to read this letter that a portion of this letter that Amnesty Malaysia received a few months ago, as is, to give you a sense of what it's like for a prisoner on death row. In Sungai Buloh prison, the gallows located just 5 meters away. The living cell and the gallows only separated by a concrete wall. The prisoner about to be executed, keep them on top of our cells. We can feel their movement whole night. Even we can talk with them by the window behind cell. We can see them going and coming from last visit with the family. And more terrible thing is we can hear very clearly the sound of hanging. Many of us have been in trauma about this matter. I don't know about you, but as I'm reading this, I'm getting goosebumps. This letter we received from a Bangladeshi death row prisoner who is here in Malaysia in the Sungai Buloh prison. And he's not the only person who has spoken about what it's like being a death row prisoner in Malaysia. The next picture I'm going to show you is of vested interest. Sharul Izani Suparman. He was sentenced to death 6 years after he was arrested for drug offences. The case around Sharul Izani is questionable. One night he borrowed a bike from a neighbor to go meet another friend at a restaurant. The friend whose bike it was told him, "Hey, dude, my bike has no road tax. So, pandai-pandai lah, be careful." So Sharul Izani, on the way to meet his friend, bumps into a police roadblock. He makes a U-turn and disappears, but tries to disappear, but the police give chase, right? They caught him and they found a plastic bag with 2 rolled up brick-like substances. And it was wrapped in newspaper. So it was 2 brick-like pieces in a red plastic bag in the basket of the motorbike. So Sharul's argument is, when I borrow something from my friend, I don't make it a habit to go through his stuff. But again, like I mentioned just now, it is up to the accused to prove innocence. So because he was found with 622 grams of marijuana, which is what those 2 bricks turned out to be, he was sentenced to death. Until today, 12 years later, he's now 31. He was arrested in 19. He's maintained his innocence. And this is a case that Amnesty globally has picked up on, and we are working towards his commutation. And that's it from me. Thank you very much.
Thanks very much, Shamini. The presentation talked about the issue of secret executions, which in the context of the death penalty for drugs is something that we find is reasonably common. Yingxi talked about it as well, and it's certainly not only Malaysia and China that practice that for drug offenses or for other offenses. For people interested in that particular issue, there's a brilliant report by the Special Rapporteur on extrajudicial killings about 4 years ago, where he demolishes. He actually uses the arguments in favor of secrecy for executions as a way to undermine the death penalty, because he sort of said secrecy in executions actually undermines all these main reasons that states always bring up. So, for example, we always hear that the death penalty is used as a deterrent, and he says, well, if you do executions in secret, how can you argue it's a deterrent if you're not telling people they're being executed? They say, well, there's great public support for the death penalty. We'll say, well, how can you say there's public support when the public hasn't even being informed about what your practice is? Or they say, well, the death penalty is about providing restitution for victims. And it's like, well, how does it actually provide restitution for victims if they don't know what's going on in the court process? It's absolutely brilliant. You can find it on the UN High Commissioner's website. But it's a really fantastic way of actually taking some of those standard traditional defenses of the death penalty and turning them around and showing the flaws.
I'd like now to introduce Ricky Ganaway. He's an Indonesian human rights lawyer and the director of the Community Legal Aid Institute. You may have heard of Indonesia recently because at the beginning of the year they executed people for drug offenses. And it's been a very big case in the news, and for some reason they stopped executions. Although they had said that they would go on with executions for drug offenses throughout the years, and they said they would execute more than 60 people over the years. But after the 2 first batch of executions, they stopped, and that would be interesting, Ricky, in hearing what you have to say about it.
Hello everyone, thank you Harm Reduction International for inviting me to speak. Just a little bit about background of the organizations. Community Legal Aid Institute provide free legal service for the poor and marginalized groups like people who use drugs, and we do a number of death penalty casework as well. I'm going to give you a brief background information about death penalty and execution situation in Indonesia, but I won't go through the law because not all of us here are lawyers, and although I myself a lawyer, I hate reading laws. It's badly written, so I won't go through the details. So this is a poster that we just published last week in commemoration of the World Day Against the Death Penalty. As Aurelie mentioned, that January 18, Indonesia executed 6 persons, all for drug offenses. Marco Archer from Brazil, Daniel Enemoa from Nigeria. Marco Archer from Brazil, 13 kilos of cocaine. Daniel Enemoa from Nigeria, 1 kilo of heroin. Ang Kim Soy from the Netherlands, 700 kilos of ecstasy, a precursor material. Denis Namaona from Nigeria, 1 kilo of heroin. Rani Andriani, female, Indonesian, 3.5 kilos of heroin. Tran Thi Han, female from Vietnam, 1 kilo of methamphetamine. All were executed 40 minutes past midnight. There was one person who was executed 45 minutes past midnight, but then he was officially declared at 1:20 because after the shot, he was still alive for some 10-15 minutes. And then because of that, the commander of the execution team shot on his head because that makes sure he's died. And from the 6 people who were executed, 3 people, Daniel Enemua, Ang Kim Soy, and Rani Andriani, they submitted clemency a few years ago, and the clemency was rejected on the December 30, 2014. So only 15-16 days after that, they were executed. According to the Indonesian law, when people were to be executed, at least 3 days before execution, they have to receive the notifications. So practically only 3 weeks, they received the notification that they will be executed. As I mentioned, the range of drugs are varied, 1 kilos, 13 kilos, and it shows that we don't have clear, like this is very serious, and then that's why we execute them, but there's a problem with the law itself. And the time range from clemency to execution shows that Indonesia was very abruptly, very hastily to execute people, because the president already announced that they want to execute soon. Like the president was inaugurated in October, and then in November he already announced that we will execute 64 people. That's going to be happen next year. So that's why everything was so sudden. This is a picture of the night of executions for the second batch of executions that took place 29th April. 8 people were executed, all for drug offenses as well. Zainal Abidin, Indonesian, 58 kilos of cannabis. Rahim Salami from Nigerian, 5.3 kilos of heroin. Sylvester Obikwe from Nigerian, 1.2 kilos of heroin. Okudili Oyatanze, 1.1 kilos of heroin. Martin Anderson from Ghana, 50 grams of heroin. Andrew Chan, Myron Sukumaran, you all know about the case, Bali 9 from Australia, 8.3 kilos of heroin. Rodrigo Gularte from Brazil, 6 kilos of heroin. I'm going to speak about Rodrigo later on, but I'm going to speak about Mary Jane's case, who was supposed to be executed, but then she was given reprieve in the very last minutes. There are 4 crosses: Sukumaran, Myron Sukumaran, Okudili Oyatanze, Mary Jane, and then Andrew Chan. A journalist sent this photo to me by mobile phone. So you can see that Mary Jane's cross was already prepared, but then like 2 minutes before executions, she was called back. She was already brought to the execution site, but then like 2 minutes before, she was brought back to her cell again, because Jokowi announced, Jokowi not really publicly announced, but there was an information that her execution should be cancelled. Her families didn't know, her lawyers didn't know. So around 30 minutes past midnight, they heard shots, and Mary Jane family thought that Mary Jane was already executed. But then when only 8 ambulances came out, and then 1 ambulance was empty without Mary Jane's dead body, and then they found out that Mary Jane was not executed. So they never got the information before the execution happened. The picture of our beloved cold-blooded President Jokowi was drawn by Myron Sukumaran, a great artist, a painter. Sorry. This is Rodrigo, my client, who was executed. Rodrigo had schizophrenia and bipolar disorder from 10 years old. He never got competent legal representation. Sorry, this is too emotional. Indonesian law does not explicitly prohibit execution for people with mental illness. We only prohibit sentencing people with mental illness, but we don't have that explicit prohibition. The Brazilian embassy, the family, repeatedly asked to transfer Rodrigo to mental health facility, but the government always denied. The Attorney General office said that they did second opinion medical result, and they said Rodrigo was fine, but we always ask, where's the medical report? Where's the second opinion result? They never announce it. We now, at the moment, attempting through right to information request to get the second opinion report. Rodrigo never knew that he was executed until the very last minute. He was handcuffed, and then he asked Father Charlie Burrows, a spiritual, religious counselor to him, am I going to be executed, Father? Did I do something wrong? Why? So Rodrigo never knew that he was already executed. 2 days before execution, I met him, and he said, oh, relax. There will be an international meeting of prosecutors. We will abolish the death penalty globally. I heard this from someone telling me. And then when I offer him drinks to talk about it, and then he said, oh, don't drink. The water from here is poison. It's intoxicated. You must be very careful. And then he said to me again, I saw someone, he said, I saw someone, Nigerian. I thought he was already executed because I heard that he was already executed, but now he's back to my cell. Why? Is he coming back from the graveyard and then trying to save me? Or what's happening? So he doesn't know that the person that he thought already executed was never been executed. That's Angelita Muxveld, Rodrigo's cousin, who fought tirelessly to help Rodrigo until the last minute of execution. So why Indonesia is so passionate or addicted to carry out executions? There are a number of reasons. At the personal level, our Indonesian president, Jokowi, really hates drugs. And like I mentioned earlier, very first month of his administration, he already announced that I will execute 64 people, all for drug offenses. I will not give any pardon, I will not give any clemency to all of them. At the political level, it's always been used as a tool to gain domestic support. During the first couple of months of administration, there was a big conflict between Indonesian anti-corruption agencies and Indonesian National Police. And then people were angry why the president was so silent. And then he used this execution to gain public support. The third one would be social religious reasons. Before executions, Jokowi visited two largest Islamic mass organizations, Nahdlatul Ulama and Muhammadiyah, to seek blessing. And then these two Islamic organizations, yeah, we support you. We support the death penalty for drug offenses. We support execution for drug offenses. And then there's the support from anti-drug civil society organization. When are you going to execute these people? like other panelists already said, they causing harms for our future generation. Our beloved children will be dead because of drug. Why will you execute them? When will you execute them? The third one would be, the fourth one would be the drug law, the policy side level. Because Indonesian drug law is very loose. It makes it easier for law apparatus, especially judges, to sentence people to death. And also the next one would be media. They're still supporting public death penalty. Only English newspaper, Indonesian English newspaper that opposed to the death penalty. The remaining Indonesian newspaper, they all support the death penalty. But who reads English newspaper? Even our parliamentarians, some of them don't read English newspaper. Some of them, they don't speak English. And then the last one would be what I would call absurd reason. Indonesian drug emergency, so-called Indonesian drug emergency. This is Indonesia Darurat Narkoba, Indonesian drug emergency. They always said 12,000 people die every year because of drugs. That equals 33 people per day. The number of drug use increasing in the 2014. There are now 4 million drug users. We have to save them. Jokowi is like Messiah. We have to save them. We have to stop this. That's why they call this Indonesian drug emergency. But I would call it Indonesian death penalty emergency. Because never been before, we executed 14 people in just 4 months. It was always 1 person per year, 2 people maximum per year. And between 2009 and 2013, we had no execution at all. But then we suddenly had these 14 executions in just 4 months. It's just, I don't want to use crazy or insane because of my respect to Rodrigo. But that's the fact. So what efforts are being taken? At the moment we have Indonesian criminal law reform, criminal law procedure reform as well. We have been drafting a new criminal code that limits the use of the death penalty, which means that if within 10 years of imprisonment you are in a good behavior and there is a hope to be recovered and there is another mitigating reason, there's no opposition from the society, and you could be commuted into life sentence or 20 years of imprisonment through the ministerial decree. And then if within the 10 years of imprisonment execution is not carried out to that person, he could be commuted to life sentence through presidential decree. And that penalty will not be implemented to pregnant women and people with mental illness, unless if the pregnant woman already give birth, then she will be executed. Unless if the people with mental illness is recovered, then he will be executed. So that's some kind of limitation or restriction. The second one is some civil society organizations are now undergoing a plan to submit a judicial review as a part of strategic litigation to the Constitutional Court to prohibit execution for people with mental illness, because we strongly suspect that around 100 death row prisoners, they have a mental illness problem. Maybe to a certain degree some are serious, maybe some are not serious. And then we also want to submit a judicial review to the Constitutional Court to interpret the current criminal code to ensure that it reflects the current draft criminal code that introduced the 10 years probation, and also which is in line with the previous Constitutional Court decision, because in 2007 the Constitutional Court already said that we cannot execute people with mental illness, we cannot execute pregnant women, we cannot execute underage children. And moving forward, I think we need support to develop capital defense lawyers in Indonesia, because very few lawyers willing, sensitive, and competent to provide a legal assistance to death row prisoners. I would say one example, Lindsay Sandiford, a British grandmother in Bali, in death row now. She was arrested by Bali police, and then she was provided the local lawyers. But her local lawyers were property lawyers, not criminal lawyers. Property, because Bali, we have so many beautiful villas and so on. So we have lots of property lawyers in Bali. And Lindsay Sandiford, drugs, death penalty cases, got property lawyers. That's one example. Another example, a British national in Tangerang, he got lawyer, and then he paid 50 million rupiahs. I'm really bad in math, but just 50 million rupiahs. And the first lawyer just took the money and then ran off. And then came another lawyer, 20 million rupiahs, slightly cheaper. And then he went off again. So lawyers only collected the money, and then they were just follow police. Just do what they say. Just say what they want. That's all. Don't ask. Just say whatever they want. Okay? That's our strategy. That's the strategy. So we have a serious problems with because we don't have capital defense lawyers in Indonesia. Sensitive, willing, and competent. Willing because it's just not about that penalty case. You have to spend time to dedicate your time to assist the client. Sensitive. Even now Indonesian lawyers, they are not familiar with drug user. Because why would I help someone who is injecting drug for themselves and then I will help them? That doesn't make any sense for me. So that's what the common lawyers think. And competent because of the types of cases that I mentioned in Lindsay's cases. Last remark I would say is that there's a good report from HRI, the death penalty for drug offenses. This is the only global annual report on death penalty for drug offenses and very useful resource. Another one from the Open Society Foundation, very useful resource as well, which was launched last week, I guess. Yeah. That's all. Thank you.
Thanks very much, Ricky, and thanks to all of our speakers today. I think we have time for a few questions. It's obviously a very important issue and one that a lot of us have continuing and increasing concerns about. So I think maybe we'll take 2 or 3 questions and then let the panel respond. Louis?
Yeah, so very quickly. I'm Louis Letellier from Montreal, Canada. I'm from Cactus Montreal, the first needle exchange program in North America, and also from the Canadian HIV/AIDS Legal Network. My first question goes to Shamini. I probably should have asked the question to the Ministry of Health, but here we are. Since yesterday, we heard so many good things about the improvement made by the Malaysian government on harm reduction. But how enthusiastic should we be when death penalty is so strongly held there? My second question is for everybody. Is there any effort or any workshop prepared for the judges or the prosecutors related to death penalty for drug-related crimes? I ask this question because in Canada, with the Canadian HIV/AIDS Legal Network, we prepared a guide related to criminalization of HIV. And we presented to judges, to prosecutors all over the country with a very good reception. And it pays. So did you have similar ideas of workshop with judges and prosecutors in each of your country?
Thank you very much, Louis. There's another hand closer to me. Yeah.
Hi, that was a very interesting and touching presentation. I'm Pani from Myanmar, and I have a question for Dr. Yi Jingbi. You presented that abolishing death penalty in China is a long way. And we have also discussed that it is important for civil society organizations to push forward in changing drug policies. So, in your opinion, what is the role of civil society in China to move against the drug policy? You know, is it possible or is it barely there? Something like this. Thank you.
Thanks. Is there, maybe take one more question and then we'll let the panelists answer. There's one woman back, there she is.
I am Tessie Castillo from North Carolina Harm Reduction Coalition in the United States. My question is, are there any statistics on rates of drug use or drug trafficking in the countries that have the death penalty, and how do they compare to countries that don't?
Thanks very much. It's all good questions. Okay. Shimidi, maybe talk about Malaysia's criminal justice policy.
Test? Okay. Thank you very much for the question. In a previous life, I was a journalist and I was a health reporter. And I was writing stories about the progress that Malaysia was making on harm reduction, talking about the NSCP, talking about methadone replacement therapy, talking about all the even condom promotion programs. But all these programs were being introduced at a time when obviously we still had the death penalty with drug-related offenses. And how it is that that's why the strategy now for civil society, and I hope I'm answering your question, is talking about abolition of the mandatory death penalty as a first for drug offense, abolition for the mandatory death penalty as a first step towards total abolition. That is basically the strategy for civil society organizations that are working on death penalty issues. So hopefully that will coincide with existing programs on harm reduction already in the country.
Yingxi, there was a question about China.
The second question for the civil society role?
Yes. Yeah, I thought I'd go for the individual questions first and then the group questions at the end.
Yes, there is possibility for civil society to involved in the pushing the movement to abolishing the death penalty in China. For example, during the discussion period of the 8th Amendment of the Criminal Law, the government has opened, I think it works like online. You can go and any individual or society to give you opinion on the amendment. And also, as I know, for example, Amnesty International is one of the big organizations that's really pushing the abolition of the death penalty in China. But how effective it is another question, I think. But yes, there are opportunity for civil society to involve in the process. Thanks.
Thanks very much. Anyone have any response to Louis' question about tools for judges or instructions to judges and prosecutors?
Yeah, I mean, we have workshop or training, general human rights training for judges, prosecutors, but it's not really systematic and institutionalized, let alone workshop on death penalty for drug offenses. I'm sure they will be allergic to that. So no, the answer is no. And there is no organization working on like developing tools or engaging with judges, prosecutors to provide trainings on death penalty for drug offenses. And the second question on the rate of drug use, we have the numbers, the report from the National AIDS Commission and from the Minister of Health, but I don't have the numbers now. But I can tell that the numbers of drug trafficking every year increase. According to the annual report of the National Narcotics Agencies, the drug crimes are always increased every year. The amount of drugs seized are always increased. But then when we raise this argument, then the counter argument would be the BNN, the National Narcotics Board would say, imagine if we abolish the death penalty, it will be more increasing. So that's the logic. Throughout that period, we always impose the death penalty and we carry out executions while the numbers are increasing, but that's how it is. I'm not sure why their logic is like that.
On the workshops, I think in India it's becoming very difficult for civil society now to engage with the police and the judges. Their trainings are mostly centralized. But I do know that the UNODC puts in money for law enforcement training. And we were recently at a drug judges training also, where members from the UNODC were present. And it was appalling that they talked about the World Drug Report and emphasized on all the problems around addiction, and very conveniently just slipped through the provisions on harm reduction and personal possession, etc. And interestingly, this UNODC gentleman also talked about the Silk Road and the whole internet-based cases, and said this is such a concern and we need to be very serious and our judges need to invoke the law, etc. So I think there's a lot of room for the UNODC. Apart from these pronouncements about abolish, I think they need to really check the work that they do within the countries, and it should be in sync. On statistics, I think India, for all the claims it makes about drug use being such a problem, more severe than murder, we still don't have any data on the extent of use and drug dependence in our country, just zero data. And of course, seizures, as Ricky said, keep increasing, but then whether the increase in seizures is actually a sign of increase in drug markets and drug activity, no such analysis available.
Great. Well, I'd like to thank very much all of you for coming. Oh, sorry, Orly, did you want to?
I just wanted to say on the judges and prosecutor, the World Coalition is a coalition of organizations, and one of our members is judges from Europe, judges for human rights in Europe. And they have been quite successful in reaching out to other judges and prosecutors in retentionist countries. It's very difficult, as you said, for civil society to engage with judges and prosecutors, because most often they don't even accept to engage in the discussion with us. But when it comes from other judges and other prosecutors, even if they're Europeans or Americans, there is a sense of peer relationship, and they agree to discuss with them. So that's a way we engage with them. And the other thing I wanted to say about crime rates and drug-related crime rates and the death penalty, there is a few reports down here if you want to learn more about death penalty and crimes. There's Harm Reduction International new reports, but also other documentation, and there's the poster available if you want also. And there's one which is called How to Answer to the Deterrent Argument. And what we did, we collected crime rates from UNODC reports, and we compared with retentionist countries and abolitionist countries. And we also compare to crime rates prior abolition and after abolition. And there's no link whatsoever. So really, you can be an abolitionist country and have very low crime rates, and you can be a retentionist country and have very low crime rates. But you can be an abolitionist country and have really high drug-related crime rates, and be a retentionist country and have really high rates. So there is no link whatsoever between crime rates and having the death penalty or not.
With regard to the workshops in China, as I can recall, because I was working outside China for the past 5 years, I could be wrong, but I don't think they're particularly designed for the death penalty or harm reduction. I can be wrong, but one I know is on human rights, and because I know scholars in the institution which I did my PhD, their scholars has been sent to China to have workshops on the topic of human rights, which I'm sure the death penalty issues such as this will be brought up. And I do know it organized by some institution in UK. If you are interested, I can check which organization it is. With regard to the data, yeah, we do have data in China with regard to the drug users. It's called the annual drug report. It's issued every year. You can check. but I don't think they have the numbers for drug trafficking, but they have the overall data for drug crimes. Okay.
Thanks, Yingxi. Please join me in giving our speakers, sorry, we don't have time for any more questions. We have to go. I don't want to keep you from your lunch. But people will be around, I'm sure, after the session and for lunch and throughout the conference. So I do encourage you to pursue more conversations on this issue. I say please join me in giving a round of applause to our speakers.